Act 1961. Based on question given, we identified one main legal issue that need to be determined. The issue to be determined are whether Kamal and Mazlan can legally dissolve the partnership under Section 37C and 37D, dissolution by the court due to Lina guilty of misconduct and persistent breach of contract. Section 3 Clause 1 of the Partnership Act 1961 defines partnership as the relation which subsists between persons carrying on a business in common with a view of profit. A partnership is essentially a contract and it gives the partner wide latitude in deciding when and how they wish to terminate or end their business. Under the Partnership Act 1961, there are several ways in which a partnership may be dissolved. First, under Section 34, dissolution by expiration. Under Section 34, a partnership form a fixed period or specific undertaking is automatically dissolved once the agreed period or undertaking ends, unless the partner agree to continue the business. For example, case Harsh versus Brick. Section 34, dissolution by notice. When the duration is fixed, any partner may dissolve the partnership by giving notice of their intention to the other partners. For example, case Satapa Chetty versus Subramaniam Chetty AR. Section 35, dissolution by bankruptcy. Bankruptcy of a partner may automatically dissolve a partnership unless an agreement provides otherwise. For example, case Sriboy.
My name is Nur Auda Adila and I will continue the another rule. Next section is also 35, which is dissolution by death. A partnership is automatically dissolved when one of the partners dies, unless there is an agreement stating that the partnership will continue. The related case is Lee Choyam Holdings, Sendirian Berhad and Ors versus Ko Yakwa and Ors. Section 35, dissolution by charge. This happens when a partner's share in the partnership is charged because of their personal debts. In this situation, the other partners may apply to dissolve the partnership. And the related case is Brown, Jensen and Section 36, dissolution by illegality. A partnership is automatically dissolved if its business becomes illegal. Once the business activities become unlawful, the partnership cannot continue. The relevant case is R versus Kupfer. And the last section is Section 37, dissolution by the court. The court may dissolve a partnership on several grounds, such as insanity, physical incapacity, misconduct, persistent breach of contract, losses in the business, or any circumstances that are just and equitable. Some related cases are Jones versus Noy, Whitwell versus Otter, and Inri Yinichi Tobacco. So let's moving on to the applications to the facts.
I will be presenting the relevant legal principle and case authorities for our case. First, let's look at Section 37C, guilty of misconduct. Under Section 37C, the court can grant dissolution if a partner's conduct harms the business nature and reputation. The misconduct doesn't need to relate directly to daily operations, but it must prejudicially affect the business environment and its commercial viability. Our case authority is JMM Lewis and Ors versus Balasingham. In this case, partners in a legal practice sued a defendant partner who was constantly absent and neglected his duties. The court ordered a dissolution because his continuous neglect directly harmed the operations and prestige of the law firm. We have Section 37D, persistent breach of contract. Under Section 37D, the court grants a dissolution when a partner willfully or persistently commits breach of contract, making it no longer reasonably practicable to carry on business with them. Partnerships are built on fiduciary duties and utmost good faith. If a partner persistently diverts common funds or break trust, the corporate contract is broken. So our case authority is Cheeseman versus Price. Here, a partner tasked with keeping the firm's account books repeatedly failed to enter cash receipts and misallocated funds. The court ordered a dissolution, ruling that his persistent accounting manipulation completely destroyed the fundamental baseline of mutual confidence between the business partners.
Applying law to Lina's conduct. By application 37 clause C, guilty of misconduct, Lina's actions are heavily calculated to affect the travel agency. Her misapplication of client funds has already resulted in an active lawsuit, directly destroying the firm's commercial reputation in a service-oriented industry. By applying section 37 clause D, which is persistent breach, Lina repeatedly diverted business funds for her personal bank accounts. She breached the core fiduciary duty of utmost good faith to Kamal and Mazlan. This makes continuing business operations impossible. Both statutory grounds under the 1961 Act are fully satisfied. As the conclusion, Kamal and Mazlan are strongly advised that they can successfully petition the court to dissolve the partnership under section 37 clause C and 37 clause D of the Partnership Act 1961. Lina's financial misconduct and the resulting reputational damage provide solid legal grounds for a judicial decree of dissolution. That's all from us. Thank you.